Nobody likes to think of their own death, particularly for those with young children. And yet making a will is one of the most important things a parent can do. Here's what you need to know. With our video guide to will writing for parents and step-parents. If you're a parent, you need to write a will. There are two main reasons for this: to ensure your children and/or stepchildren inherit, as you wish, and to ensure that any children under the age of 18 would be appointed to the care of a guardian, rather than being taken into the care of social services. Despite these important considerations, 54% of parents don't have a valid will, according to WillAid. This video is a brief guide to making a will as a parent. We hope that it makes a difficult topic a little easier. Inheritance laws for children and stepchildren. Modern families can be complicated, with different parents and children forming a family unit. Inheritance is complicated further by whether parents are married or unmarried. It's important to note that stepchildren do not have an automatic right to inherit anything. This is in stark contrast to the right of your own children to inherit. Automatically under the law, adopted children have the same rights as natural children. What to do to ensure your children and stepchildren inherit as you wish. If you'd like your stepchildren to receive any portion of your estate upon your death, they must be named in your will. Sometimes, parents in new relationships do not want their stepchildren to inherit anything. This should be made clear in the will. It's also a good idea to include a letter of wishes alongside the will to back this up. Who becomes your child's guardian in the event of your death? The short answer is that if there is not another parent, the child is placed in the care of social services. Many people assume that if they were to die, their children would go to live with grandparents, aunts and uncles, or maybe godparents. This is incorrect. If you're making a will, and you have children under the age of 18, consider who'd be willing and able to look after them if you couldn't. Bear in mind the child's perspective, as this would be an extremely distressing time for them. Do they like the nominated family member? How would it impact their schooling, where they live, or any religious considerations? It's vital that you speak to the guardian you have in mind too. If the worst were to happen, are they prepared for the responsibility? Seek professional advice on making a will. The idea of missing out on your child growing up, of not being there to look out for him, is distressing. We understand it's not an easy subject. However, the implications of not having a will in place is much greater for your family further down the line, if the worst were to happen. If you'd like to write a will but you're unsure where to start, perhaps My Family Legacy can help. We answer difficult, complex questions in a sensitive manner. Get in touch to see if we could help you, no obligation. Contact us at My Family Legacy. Our telephone number is 0117 279 5507. Our email address is support@myfamilylegacy.co.uk and our website address is www.myfamilylegacy.co.uk. We look forward to hearing from you.